Hello friends, in the series on the income tax cases, today we will discuss a case which is of practical importance. This issue which is discussed in this case is very useful for all those assessees who purchases flats, and when the flat is purchased, allotment is done to them, but the payments are made over a period of time and the registry of the flat is done after a substantial period of time. As all we know that to curb the black money transactions, the concept of stamp duty valuation was adopted by the Income Tax Department in 2003 by introducing Section 50C. Section 50C is applicable to the seller, so to cover the buyers, the legislature introduced Section 56 subsection 2 clause 10. Section 56 subsection 2 clause 10 broadly says that if any assessee purchases a property whose consideration is less than the stamp duty valuation, then in that case the difference between the transaction value and the stamp duty valuation will be added into the income of the assessee. But at the same time, there is first and second proviso to Section 56 subsection 2 clause 10 clause B, which says that the stamp duty valuation is to be seen at the date of the agreement to sell and not at the date of registration of the property, subject to that there is agreement to sell and the transaction is completed by giving some advance at the time of making the agreement. But the question arises that whether there is no agreement to sell but only allotment letter is there, so whether allotment letter can be construed as an agreement to sell. This was the issue in the case of Sulochana, Saijan Modi versus income tax officer. This case has been reported in 120 ITR Tribunal, page number 92, and the matter has been decided by Mumbai ITAT, and the date of the judgment is 23rd May 2023. The present case relates to the assessment year 18-19. The facts of the case are like this. The assessee's son had been allotted the property earlier and the assessee became the co-owner of the property. When the assessment proceedings were going on, the assessing officer noticed that at the date of the registration of the property, the stamp duty value was more than the transaction value, so he added the difference between the transaction value and the stamp duty valuation. But at the time of the assessment proceedings, it was the contention of the assessee that the stamp duty value of that flat was less at the time of the allotment. So the stamp duty valuation at the date of the allotment should be seen and not at the date of the registration. But the assessing officer said that there is no agreement to sell. So in that case, the allotment cannot be considered as agreement to sell. This was the limited issue. When this matter came to the CIT appeal rejected the appeal of the assessee on the same ground which the assessing officer has taken. When this matter was brought to the tribunal said that in the present case, the first and second proviso to Section 56 subsection 2 clause 10 clause B are fully applicable because the condition of the part payment was not in dispute. The tribunal also said that registered deed is indicating check payment in respect of the allotment along with bank statement, and the allotment letter should be considered as the agreement to sell because the payment has been made earlier at the time of the allotment, and in the present case the assessee should be given the benefit of first and second proviso to Section 56 subsection 2 clause 10 clause B. The reason for taking the stamp duty valuation at the date of the allotment is also that because at that time the parties entered into a transaction and their mind were colliding with the fact that they have to give this value. So the registry may take place at a later date, but the agreement to sell or the allotment may be earlier. So the section gives itself the benefit of taking the stamp duty valuation at the time of allotment or the agreement to sell. So in the present case, the tribunal remitted the matter back to the learned assessing officer on the limited point that the assessing officer has to compare at the date of the allotment the stamp duty valuation of the property and the transaction value and give the relief to the assessee accordingly. At the end of this video, once again I am repeating the name of the case. The name of the case is Sulochana Saijan Modi versus Income Tax Officer, and this case has been reported in 120 ITR Tribunal at page number 92. The matter has been decided by Mumbai ITAT and the date of the judgment is 23rd May 2023. Thank you friends.